I want to thank all of you ahead of time for coming back on time. I tried talking to Scott and talking him into doing like a structured nap time because I thought it would go over well. So that's what this is. This is actually bankruptcy/structured nap time for how many family law practitioners do we have out here? Okay. Any bankruptcy attorneys? Okay. You're actually going to come up and do the presentation, sir? Okay. I want to start out by pressing the right button. I'm doing bankruptcy basics for the family law practice. I want to first note that I don't do bankruptcy. It's a disclaimer alert and the same disclaimer that I give to all of my clients. I'm not a bankruptcy practitioner. However, in order to be an effective domestic relations practitioner, I have to have a basic understanding of bankruptcy law to advise my clients accordingly. Every time a client or potential client meets with me and presents a sizable debt-to-income ratio, I refer to a bankruptcy attorney to evaluate the client's options. The client may not have considered bankruptcy before for a variety of reasons, or the client may not even realize the situation that he or she is in, which happens all too often. But during our initial consultation, I asked the client to give me a rundown of all the assets and all the debts. And sometimes the client hasn't even considered his or her entire financial picture. They're just living in the moment, getting by, robbing Peter to pay Paul. So I have to recognize a potential bankruptcy situation when I see one, not only as a benefit to my client, but a risk if opposing party were to file without my client either during or after the divorce process. And finally, when it comes time to drafting a property settlement agreement, I need to carefully draft language in cases where we're planning a bankruptcy or we know a bankruptcy filing is possible on the other side. Bottom line, today you are not going to learn how to file a bankruptcy action on behalf of a client. Rather, we're going to go through some basics that all of us should have in our arsenal. I highly recommend developing a relationship with a bankruptcy attorney. Man in the shirt right there, he would be happy to be your friend. And developing a relationship, and hopefully the door swings both ways and you're able to offer advice on your area of law. But my goal today is to help you spot an issue. Once you spot the issue, you need to bring the bankruptcy expert in. And do not give your client bankruptcy advice unless you are a bankruptcy attorney. Let's start by identifying what causes bankruptcy. And here's a slide on the 10 leading causes of bankruptcy. Number one being medical expenses, and recent studies have indicated that 42% of all bankruptcies, personal bankruptcies, are a result of medical expenses of those who filed. And what's interesting is that 78% of them had insurance at the time. Number two, job loss. Number three, uncontrolled spending. Number four, the effects of divorce. Number five, an unexpected disaster, such as a natural disaster, which destroys a home, and the person doesn't have an adequate homeowner's insurance. Number six, avoiding foreclosure. Some parties will file for bankruptcy to reorganize the debts attached to their home to avoid the foreclosure. Number seven, poor financial planning. Now, you have to question whether these are mutually exclusive categories, but these are the reasons that parties gave for why he or she filed for bankruptcy. Number eight, preventing loss of utilities. Number nine, student loans. Although you cannot discharge student loans except in extraordinary circumstances, according to this site, it may be possible to consolidate student loans with a bankruptcy. And number 10, preventing repossession. If a creditor repossesses your vehicle or other personal property, the bankruptcy may force the return of the property. Chapter 7 and Chapter 13 are the two most common types of bankruptcies that we come across in family law proceedings. A third type, Chapter 11, is generally reserved for those individuals who are not eligible to file a Chapter 13. Chapter 7 is referred to as liquidation. Chapter 13 is the repayment plan, and Chapter 11 is reorganization. Today we're going to focus on Chapter 7 and 13 as they're the most common bankruptcies that as a family law practitioner you would come across. Before the individual debtor files the petition for bankruptcy, he or she is going to meet with the bankruptcy attorney. The attorney will apply the means test to determine if the debtor qualifies for a Chapter 7 or if he or she must file a Chapter 13. The means test measures the income of the debtor against the national IRS standards for living expenses. This is something that a bankruptcy attorney has to analyze, and there is a period of time that the attorney is reviewing for income, and there is more complicated formula that the attorney can use when the party is right on the line, and it may or they can push them into a Chapter 7. There are online calculators available, but again, I do not advise my clients whether he or she will qualify for one plan or the other. I defer and refer to the bankruptcy attorney. The attorney will then advise the individual debtor of the options for relief. And note, there are reasons why you would file a Chapter 13 even if you qualify for a Chapter 7. Pursuant to the 2005 Bankruptcy Act, sorry, I had to get up to my slide here. The individual debtor must undergo credit counseling within 6 months before filing for bankruptcy relief. And finally, the paperwork gathering begins. Bankruptcies are paperwork intensive, and legal assistance are an integral part of any bankruptcy practice. Typically, the bankruptcy attorney is looking for the last 2 years of financial history, including income, debt, and major transactions. This is also a point where the bankruptcy attorney and the family law attorney can benefit by sharing information that they've already gathered. As the family law attorney, you probably have most, if not all, of the documentation the bankruptcy attorney would be looking for. Unlike in divorce cases, one bankruptcy attorney can represent both the husband and the wife in a bankruptcy action. However, the bankruptcy attorney cannot represent the parties if they have adverse interests. If the bankruptcy attorney says that the interests of the parties are not adverse, then the parties can proceed with the same attorney. There are issues for the parties to consider whether they want to have a joint attorney. One is confidentiality. If there is a dual representation, the bankruptcy attorney must make clear to the parties that he or she is not having any communication with one party that is confidential to the other. Another consideration is that the parties have to agree on what the income, assets, and debts are if they're going to be filing a joint petition for bankruptcy. We've all heard something along the lines of, you know, he has a side business for cash, or she doesn't report all the tips that she's receiving. If the parties are unable to agree and sign one disclosure, then dual representation may not be for them. Ultimately, it's up to the bankruptcy attorney and the parties to make the decision whether they utilize the same attorney for their bankruptcy. Going on to the basic process, let's start with the basics of a Chapter 7 bankruptcy action. And just to give you guys a little preview of what we're going to do today, we're going to go through the meat of the presentation, and at the end, I know you all just had lunch, so right now we're relaxing, and then the end of our presentation, we're going to do something a little bit more interactive and kind of kick it up, make it a little bit more exciting. So talking about the basic process, Chapter 7 is liquidation. The petitioner is essentially throwing all of his or her assets and liabilities into a pot. From the pot, they get back the assets that are exempt from the estate, and the remaining assets, if there are any, are then liquidated by the Chapter 7 trustee for the benefit of the estate's creditors. The basic process of the Chapter 7 bankruptcy begins with the debtor filing a petition for the bankruptcy. Once the action is filed, there's an automatic stay instituted as to the petitioner, which we will discuss shortly. A trustee is appointed at the filing of the petition for the relief, and a first meeting of creditors is held approximately 30 days after the date of filing. Now, during the bankruptcy process, the debtor files a variety of schedules which identify the assets, the debts, and also notes what assets he or she believes are exempt pursuant to the laws of his or her jurisdiction. These exemptions include dollar-specific exemptions for a person's homestead, personal property, wages, pensions, public benefits, alimony and child support, insurance, business partnership property. There are also wild card provisions and other federal non-bankruptcy exemptions. I've included in the Missouri exemption list in the materials. I believe it's on the jump drive that you received. And it includes the type of asset, the dollar amount of the exemption, and the applicable statute or case law for you. Because the list of exemptions are so specific and they're derived from a variety of statutes, you should not advise your client whether an asset he or she would be receiving would be exempt. Rather, you defer that to the bankruptcy expert. And once these schedules are received, the trustee determines which assets may be seized and liquidated and which assets are exempt. These assets, the assets that should be liquidated will be liquidated, and again, the value received is distributed to the creditors accordingly. Assuming that the debtor complies with the bankruptcy code, the dischargeable debts are discharged. There are hiccups that can certainly occur along the way. A creditor can object to the bankruptcy discharge. Adversary proceedings can take place. So this is just to show you a basic process. An adversary proceeding could be filed arguing that a debt should not be discharged, a claim of bad faith, or a trustee could file alleging that the debtor was not truthful on his or her schedules. There are lots of situations where the bankruptcy can be derailed. But assuming a smooth sailing through the process, a Chapter 7 bankruptcy will typically take between 3 and 4 months from the time the debtor files the bankruptcy until the discharge is granted. Again, that's only if it's smooth sailing. With respect to timing, we have to ask, well, when should the party file the Chapter 7 action? For our purposes, we're questioning whether this should occur before, after, or during, before, during, or after the divorce action. If the parties file a Chapter 7 before the divorce, this allows the couple to dispose of all the debts prior to the divorce action. I had one bankruptcy attorney who called this the happiness package. This can be a joint petition since the couple is still legally married. It does not matter if they're physically separated, just that they're married. This process requires some cooperation between the husband and wife to provide documentation to the attorney and attend the 341 meeting of creditors. The nice part about filing before is that the debts are discharged, and we do not have to address those debts in the decree and include language that there are fallbacks if one party backs out of the bankruptcy or if the bankruptcy is denied. It's taken care of, and we can take the issue of the dischargeable debts off the table. If they choose to file during the divorce, sometimes the issue of bankruptcy isn't really considered until the parties realize that their financial situation is truly unmanageable, especially once they're trying to support 2 households on the same income that they failed to support 1 household with. A bankruptcy filing would stay the divorce proceedings for the 3 to 4 months. The divorce could not continue until the discharge or if one party sought relief of the automatic stay. Since the parties are still married, the petition could be done jointly or as individuals. The bankruptcy would relieve one or both of the parties of the debt, regardless of how the original divorce petition proposed the debt distribution. Whether it be before or during a divorce action, one spouse may file bankruptcy on his or her own. That spouse would be able to discharge the debt because both spouses are responsible for the debt incurred during the marriage. The creditors would then simply pursue collection from the entire debt against the non-bankrupt spouse after the divorce. A divorce court may not order the spouse who was discharged to then pay the debt, and a divorce court cannot keep the creditors from pursuing the non-bankrupt spouse since the divorce court has no say over the contract between the creditor and the debtor. The divorce court only has the ability to assign the debts between the spouses. Also, for the purposes of the means test, it's important to note that if one spouse files bankruptcy, the other spouse's income must be included in as much as it's contributing to the household of the filing spouse. No matter what, the income has to be identified, but if the person is not contributing to the household of the filing spouse, then the income is not considered when applying the means test. And finally, the parties can choose to file Chapter 7 after the divorce, but that can only be filed individually. If the filing party has a domestic support obligation, he or she still owes the debt and must make the ongoing payments. And if the filing party was ordered to assume debts from the non-filing party as part of the divorce judgment, for example, there's hold harmless provisions that you're supposed to pay this credit card, then that debt is not dischargeable in a Chapter 7 bankruptcy. Next, looking at the basic process of the Chapter 13 bankruptcy. In a Chapter 13 bankruptcy, the debtor enters into a repayment plan to settle debts. These plans are 3 to 5 year repayment plans that are overseen by the bankruptcy court. During this time, the debtor makes the monthly payments to the bankruptcy court, and any property tied to the debt, such as homes, cars, remain in the possession of the debtor. For that reason, the debtor has to have regular income. The amount of the payment plan is determined by taking the debtor's disposable income and subtracting the allowable expenses. The first steps are the same as a Chapter 7 bankruptcy. However, in a Chapter 13, a proposed payment plan has to be submitted 15 days after the filing. And then there's a confirmation hearing to confirm or deny the payment plan. If the debtor successfully completes the plan, the dischargeable debt is discharged at the end of the plan term. Recent statistics suggest, however, that only about a third of all of the Chapter 13 bankruptcies are successfully completed. In your materials, you're going to find a basic comparison of Chapter 7 and Chapter 13. Again, that's on the jump drive, and that's from the State Bar. The American Bar. We also have timing questions in a Chapter 13 filing. The parties can initiate a Chapter 13 before the divorce. The Chapter 13 can still dispose of all the debt and can be filed jointly as the divorce has not occurred, but the debtors will need to seek relief from the stay before he or she files the divorce pleadings. The divorce pleadings regarding debts must reconcile with each debtor's intentions in the Chapter 13 filing, and the case can be split into two cases if the debtors cannot work together throughout the 5 years. A Chapter 13 can be filed during the divorce. The Chapter 13 stays the divorce pleadings, and a party would need to seek relief from the stay to continue with the pleadings. While technically still married, a joint petition is still possible, and the separation of marital debts would have to be reconciled with the Chapter 13 pleadings. Finally, a party can initiate a Chapter 13 after the divorce, or as I would like to refer to as the bankruptcy bomb in family law. This typically gets like a smirk from the bankruptcy attorneys where they can make a whole lot of mess to what we thought was a carefully crafted plan. I see that smirk. I see it. This is typically filed the day before a contempt hearing. Since Chapter 13 allows you to discharge the marital debts created in a divorce or a settlement agreement, this has the potential to be a devastating hit to the non-filing spouse. The non-filing spouse must understand that a divorce decree is a contract between the two divorcing parties, and creditors are not bound by this agreement. If they're still on the debts, the creditor has every right to collect from any other individual that signed on the debt and to negatively report on that person's credit. If the debt is not characterized as a domestic support obligation, then the debtor will be able to discharge the debt. This is a situation you have to keep in mind as you're drafting a settlement agreement and a risk that you have when you leave the drafting to the court. If I have a client who intends to drop the bomb, I want to make sure that none of the debts are classified as a domestic support obligation and that there are no hold harmless provisions. And I take my marital settlement agreement or property settlement agreement and I send it over to my friend, the bankruptcy attorney. I say, okay, make sure you give this a look over and let me know that it's okay. Example, retirement assets, and you also want to make sure that my client receives as many of the exempt assets as possible for the retirement assets and home with equity. If I have an inkling that the opposing party is going to file, I want to make sure, one, there's a hold harmless, and that there's language indicating that the debts the opposing party is ordered to pay is in the nature of support, and I would want to add details explaining why and how this is classified as support from my client. And we're going to talk about sample language the second half of this presentation. So to take a step back, we have to ask, well, what assets are in the bankruptcy estate? Once relief is sought, the debtor has no power to transfer, sell, encumber, or dispose of property in the bankruptcy estate. The Bankruptcy Code defines property very broadly as legal and equitable interests of the debtor and any property that is community property of the debtor and his or her spouse. And that's from 11 U.S.C. 541. Even the property that the debtor selects as exempt property is property of the state until the exemption claims are final. And this occurs generally 30 days after the 341 meeting. So more specifically, what does it include? In addition to the obvious tangible assets of the debtor, property of the state also includes such things as the right to file a lawsuit, stock options, the right to inheritance received within 6 months after the bankruptcy is filed, tax refunds for pre-petition years, and intellectual property, and even tax attributes such as lost carryovers or carry forwards. There are assets that will be specifically excluded from the bankruptcy estate but must still be disclosed. The most important exemptions to the all-encompassing definition of the property of the estate are the debtor's rights in spendthrift trusts and in ERISA qualified retirement plans and 401k plans. Those kinds of property are not property of the estate. If an asset is not property of the estate, the debtor does not have to claim it exempt to protect it from creditor claims, still has to disclose it, but it is by definition beyond the reach of the creditors and the trustees. Okay, so we know what assets are going to be in the bankruptcy estate, but what debts can the client eliminate with a bankruptcy filing? The better question is, what debts cannot be eliminated with a bankruptcy filing? And in order to answer this question, we need to know whether the parties are filing a Chapter 7 or a Chapter 13. I've included Section 523 sub A of the Bankruptcy Code in your material, which includes an exhaustive list of non-dischargeable debts. A non-dischargeable debt is a debt in a category of debts Congress has determined should not be dischargeable for public policy reasons. For most of these categories, the debt is outright non-dischargeable, bless you, unless extraordinary circumstances exist. It's important to note is that a creditor must challenge the discharge of the debt during the bankruptcy case in some of these instances. Though not all, in situations where the creditor must file a claim, if a creditor doesn't raise an objection or it does and the court disagrees, the debt will be discharged. Bottom line, if you or your client receives a bankruptcy notice, contact a bankruptcy attorney right away. Let's first look at the non-dischargeable debts when a person is filing a Chapter 7 bankruptcy. There are 19 categories of debts that are non-dischargeable under a Chapter 7, and there's a more limited list for Chapter 13, meaning more is dischargeable under a Chapter 13 plan. I included the statute in your material, but I want to focus on the most common types of non-dischargeable debts that we see as family law practitioners. One is student loans, and those are non-dischargeable with rare exceptions. Income taxes that are less than 3 years old, but to eliminate the income tax debt, the tax return must have been originally filed at least 3 years before the debtor filed the bankruptcy petition. A Chapter 7 bankruptcy will wipe out the debtor's personal obligation to pay the debt so that their bank account and wages won't be garnished, but if the IRS recorded a tax lien on the property, the lien will remain on the property. Property taxes with some certain exceptions, child and spousal support, these are domestic support obligations, and divorce property settlements. If a spouse is responsible for paying certain debts which are outlined in the agreement, then these obligations cannot be discharged in a Chapter 7. And finally, fines and restitution imposed by a court for any crimes committed by the debtor. A slightly broader discharge of debts is available to a debtor in a Chapter 13 case than in a Chapter 7. Debts dischargeable in a Chapter 13 but not in a 7 include marital debts created in a divorce or settlement agreement. It's worth noting that the law in effect from 94 to 2005 had this balancing test where the debtor could discharge the marital debts if he or she could show, one, inability to pay, and two, that the benefit to the debtor outweighed the detriment to the former spouse or child for the discharge of the debts. That has since been amended, and now property settlements are dischargeable under Chapter 13. Debts incurred to a non-dischargeable tax debt, debts incurred to pay a non-dischargeable tax debt, court fees, condo, co-op, homeowners association fees incurred after the bankruptcy filing date, debts for loans from a retirement plan, debts that couldn't be discharged in a previous bankruptcy, and willful or malicious injury to the property. Domestic support obligations are still not dischargeable under a Chapter 13. The following debts are presumed non-dischargeable. Non-essential luxury credit card debts to any one creditor totaling $500 or more that was incurred 90 days prior to filing. Cash advances over $750 within 70 days before filing. And debts the creditor can prove that the debtor incurred with no intention to pay. So the free-for-all, the eve before bankruptcy filing is not going to fly. If the client has purchases that fall into any of one of the above categories, the bankruptcy attorney is going to advise the client to wait until after that 90-day presumption period is passed. So to take another step back, we have to ask, what is a domestic support obligation? Again, these are non-dischargeable debts under 11 U.S.C. 523 sub 5. The Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 introduces the term domestic support obligation. And that definition is set forth in Section 101.14a, and I included that definition in your material. It includes a debt owed to a spouse which is in the nature of alimony, maintenance, or support and established by agreement or court order. The obligation must be owed to or recoverable by a spouse or former spouse or child of debtor or child's parent, guardian, relative, or government unit. How many of you are making arguments in your head right now with the language in the nature of support? Clearly, you call it alimony, you call it child support, those are domestic support obligations. But what about an alimony buyout, or one party taking all the debts of the marriage to get out of the alimony buyout? The case law that guides the bankruptcy judges directs the court to look beyond the labels that we use and to determine the intent of the parties and whether the obligations created are to remain in the nature of alimony, maintenance, or support. The bankruptcy court may actually hold evidentiary hearings to determine whether an obligation is a domestic support obligation. And we're going to talk about drafting techniques later in the presentation. In Re Sora, which is a Sixth Circuit case, the court stated regarding domestic support obligations, if it looks like a duck, walks like a duck, quacks like a duck, then it's probably a duck. There are a variety of factors that the court uses to guide the court in determining whether an obligation is a domestic support obligation. I know that these can be a little difficult to read, so I'll read them aloud quick. The amount of alimony, if any, awarded by the state court and the adequacy of any such award, the need for support, and the relative income of the parties at the time the divorce decree was entered, the number and age of the children, the length of the marriage, whether the obligation terminates on the death or remarriage of the former spouse, and whether the obligation is payable over a long period of time, the age, health, education, and work experience of both parties, whether these payments are intended as economic security or retirement benefits, the standard of living that was established during the marriage, and the language of the divorce agreement. But notice that the language of the divorce agreement is only one of the factors. The relative financial positions of the parties at the time of the agreement, the amount of property division, the number and frequency of the payments, whether the agreement includes a waiver of support rights, and whether the obligation can be modified or enforced in state court, and whether the obligation is treated as support for tax purposes. There are a lot of cases out there as to what is and what is not a domestic support obligation. I will note that a party's obligation to pay guardian ad litem fees, for example, have been found to be a domestic support obligation and are non-dischargeable. So when it comes to trying to make clear what an obligation is intended to be, when an obligation is intended to be a domestic support obligation, the key is to say what you mean. Make a record of your intentions in settlement agreements and ask the court to clarify intentions on the record when it's a court ruling as opposed to a settlement agreement. Go beyond just calling it a domestic support obligation. Labels are not conclusive. Again, the court is to look at the intentions. So while the label doesn't hurt, you should go a step further and list the factors that give your client a need for or no need for support. An example is this obligation is essential to enable X to maintain basic necessities. If you believe a bankruptcy case is in one or both of the parties' futures, state so precisely. But remember, you cannot draft an agreement that states neither party is allowed to file bankruptcy. Also, the circuit court must understand that this is not within his or her authority. Horror story, I got in a heated moment with one of my judges in Wisconsin. It was in Milwaukee, so probably none of you will ever come across her, so I can tell the story. Your judges are probably all perfect. Got in a heated moment about, and thankfully this judge is now rotated out of family law. I wrote what I thought was a very comprehensive and convincing memorandum to the court, identifying the issues in the case, and my fear was that I knew that the opposing party was going to file bankruptcy, leaving my helpless client high and dry. What he did was he basically, all the assets that were awarded to her post-divorce, he liquidated them after the divorce without her knowing. He had a maintenance obligation that he decided he wasn't going to pay. And the judge just, she had it set in her mind what she was going to do. I was asking the court to make a clear and clean record using the factors the bankruptcy court would be using to bolster what we knew would be addressed in future litigation as to whether the obligation was a domestic support obligation. Instead, the judge made an order that the opposing party was not to file bankruptcy or he would be immediately placed in jail. She told him to bring his toothbrush if he did that. And any attorney that filed bankruptcy on his behalf would also be held in contempt and sanctioned to jail. Telling her, Your Honor, you can't do that. Wasn't working. The Supremacy Clause had no power over her. The bankruptcy court will determine whether an obligation is a domestic support obligation, and the bankruptcy court will accept the bankruptcy filing, and this judge would be prohibited from enforcing a property division issue once a bankruptcy action has been filed. And that, my friends, brings us to the automatic stay. The filing of a bankruptcy operates as a stay against all acts to acquire property of the debtor or to recover a claim against the debtor that arose pre-petition. The 2005 Act expanded exceptions so many family law matters can still continue except matters relating to property division. If you choose to proceed with an action even though the stay is in effect, not only may the judgment be found to be void, but the creditor and his or her attorney may be subject to sanctions for violating the stay and bringing the action to state court, or for failing to take corrective action once the attorney or the party is aware of the violation. So it's important to know what you can and cannot do once the bankruptcy action is filed. The automatic stay prevents commencement or continuation of any proceedings, any court proceedings, but there are exceptions. It prohibits the execution by a judgment creditor against the debtor or property of the bankruptcy estate, and this includes attempts at wage garnishment and bank garnishment and execution sales. It also prevents repossession, any act to collect, assess, or recover any claim against that arose prior to the date of filing, any act to create, perfect, or enforce a lien against the property of the debtor. And note, there is a Chapter 13 co-debtor stay, which protects a non-filing creditor or co-debtor. Under the co-debtor stay, the creditor is stayed from commencing or continuing a civil action to collect a consumer debt from a co-debtor who is liable on a debt or who secured a debt of the debtor. This only applies if he or she is a co-debtor within the meaning of the statute, which is 11 U.S.C. 1301. Well, how long is this automatic stay in effect? According to 11 U.S.C. 362 sub c, the automatic stay remains in effect until the earlier of the case is dismissed or closed, the debtor is discharged. Remember, in a Chapter 13, this is in effect until the plan is complete, so 3 to 5 years. I actually just had this come up just recently. I was retained in a case pretty much at the end. Parties have a divorce hearing that was scheduled actually April 3rd, so it was that Wednesday. I'm brought on in the middle of March to do negotiations, and we reached an agreement, and in this process, I assumed that opposing counsel, because this action had already been going for so long, that they had requested a stay. These parties were in a Chapter 13 repayment plan. Nope. So you want to have a final hearing on April 3rd, and we haven't even talked to the bankruptcy attorney about that? Okay, let's get a little bit more creative here, because the automatic stay is in effect until that payment period is over, or when you receive an order for relief from the stay. A stay regarding property may be lifted for cause, including allowing the state court to adjudicate rights of the spouses and property. Even though distribution of property of the estate is under the jurisdiction of the bankruptcy court, this can be done by stipulation for relief, and there's a form that you have to file, or a motion for relief from stay, but note that a motion in most jurisdictions is going to require a filing fee, and because I do not practice in federal court, I always refer to the bankruptcy attorney to get the relief from stay. as I said earlier, there are exceptions to the automatic stay, and there are these are listed in 11 U.S.C. 362 sub B sub 2. That includes an action to establish paternity, an action to establish or modify support, an action to collect a domestic support from property that is not property of the estate, action for child custody and visitation, actions concerning domestic violence, including prohibiting a debtor from entering his or her former home, actions to withhold income, including income that is property of the estate for payment of a domestic support obligation. And there is a caution for Chapter 13 plans, an action to collect support when the payment is provided for by a Chapter 13 plan. It is not a violation of the stated proceed, but it could be a violation of the order for confirmation. And finally, an action for reporting of overdue support for certain purposes. Now we're going to run through some scenarios. I want everybody to close their materials because we're going to go into little groups. So everybody's going to get a little bit more friendly with the people next to them. And I don't want you to read ahead. So let's just work this out with our neighbors and think about what you would really do in a situation. And bankruptcy attorneys, no cheating. All right, everybody ready? And I have the mic, and we're going to travel in the group to make sure we get the answers right. So, first scenario. Both parties agree that one party is filing Chapter 7 following the divorce. You represent Party A. I want you to work with your team, and everybody should have a pad of paper in front of them and a pen, and make a list and identify, 1, what risks do you see? And then 2, I want you to draft sample language regarding the division of debt. It just has to be a paragraph. All right? So everybody take the time. We're going to, we have quite a few scenarios to go through, and then we're going to work it out together. And actually, I'm going to call upon somebody to participate. So everybody is at risk for having the microphone in their face. So please work together. Again, what risks do you see, and what is the sample language? All right, is everybody ready? I do have a victim, my first victim, and we're going to name everybody around the room. But Peter Maginot is fiercely writing down what his answer is going to be because he didn't realize that I was actually going to call on somebody to read what they were going to write. And so we're going to do that. So keep that in mind in the next round. All right. So both parties agree that they're going to file a Chapter 7 following the divorce. What risks do we see? Well, what is your name, sir? Red sweater? I'm sorry, you made him do the... Oh, you're... What are you going to tell that to the judge? Okay, let's do it together. Let's do this together. Should we make the... I think we need to make the intentions clear, right? What are the risks do you see?
Well, with regard to the filing of Chapter 7, you got if both parties are going to be doing filing, you got to be careful that somebody doesn't go out and run up the path prior to the actual filing. So you got two parties, lack of communication between the two parties, or nefarious conduct.
Do you have you ever drafted a property settlement agreement?
Sure, yeah.
Do you hold harmless pretty standard in yours?
Yes. Yeah, you would. You'd also have some recitals about full disclosure too.
So if they're filing a Chapter 7 bankruptcy, one thing is we need to exclude that hold harmless, right?
I would say yes, certainly, even if my eyesight doesn't feel me.
All right, so we have to make our intentions clear, make sure there's no hold harmless, and do we have some sample language, or should we be nice to you and we'll let you just read mine? Okay, all right. So this is some sample language, and it's in your material. That's why I made you close your material, and I will be watching to make sure you guys, you're already grabbing the folder. You're not supposed to open your material. Okay, here we go.
Creditors are not bound by this agreement, and each party may remain liable to creditors for all marital debts. It is understood that Party A will file bankruptcy shortly after the judgment of divorce. It is understood and agreed that all marital debts will be included in such bankruptcy. The parties acknowledge that there is no hold harmless provision with respect to the debts outlined below, as it is anticipated that one or both of the parties will be filing bankruptcy to discharge his or her obligations to the debt. It is understood that Party B may proceed with the bankruptcy filing if the creditors choose to pursue collection of the debts from her. Party B will have no remedy from Party A with respect to the payment of the debts outlined below.
All right, bankruptcy attorney, raise your hand again. Stand up. Where is he? Did he leave us? Is there another bankruptcy attorney in the room? Anybody? All right, then are we okay with this language?
I would have added another paragraph.
Oh, hold on 1 second. I am going to. Okay. All right. What would you have added?
So we're representing the non-debtor spouse or the debtor spouse here? Which one?
Party A. So the person who's going to file Chapter 7.
Okay, then you want to make sure that you characterize all the indebtedness that's incurred in the divorces, non-DSO language, like attorney's fees, court costs, expenses of litigation. Otherwise, those would be non-dischargeable no matter what the other guy did in the settlement. So it would be just the reverse if you were with the other party.
All right, everybody got that? So make sure you classify that, make sure you make a specific reference that there are no domestic support obligations with respect to the debts.
My question is, why don't they go ahead and file the bankruptcy before the divorce is finished?
Why do parties do a lot of the things we don't? No. Okay, here's actually an answer. In this situation, Party A and let's say Party B wants to take the risk. I don't want to file a Chapter 7. I don't want to file the bankruptcy because all the debts are in your name anyway. So how about we do this? How about we wait? You file Chapter 7 bankruptcy, and you're going to file bankruptcy, and we'll wait and see if the creditors come after me. If they come after me, I file Chapter 7. But if they never come after me, because the debts are all in your name, the creditors might not. Like, let's say it's a debt to a major credit card company. You're not on their radar. Great, you didn't have to file Chapter 7. You didn't have to file bankruptcy. So it's just an option. But as the representative of Party A, I need to protect Party A so that Party B can't say, well, no, I didn't know you were going to file Chapter 7 bankruptcy. So we have the protection there, but Party B may not end up having to file Chapter 7 because the creditors might choose not to go after him or her. All right, we're going to move on to the next scenario. So that's under Example A in your handouts that are in your packet. But close your material. Everybody close your material. No cheating here. All right, next scenario. Your client fears the opposing party is going to file bankruptcy and discharge the debts following the divorce. You represent Party A, and I want you to work with your team to make a list and identify what risks you see, and then draft language regarding the division of debt. All right? We're going to have about 3 minutes in a group, and you don't have to actually have the language, but just give me your key points. What types of language, is there going to be, I'm not even going to give you examples, but we can kind of go off of, what did we hear the last time? We heard keywords of hold harmless, domestic support obligations. So keep that in mind, work with your group. We'll have a couple minutes, and then I'm going to choose a victim. All right, everybody, we have Stephen Harden who volunteered. Is that actually your name? Is this yours? Okay, so this is Steve. Hi, Steve. All right, Steve is going to talk about the risks that he sees when we have our client, Party A, is concerned that Party B is going to file divorce shortly after and try to discharge the debt with the Chapter 13.
If the other party files, there's a very good chance that your client's going to end up paying all those debts. You can attempt to put it in Chapter 7. 13? Oh, yeah.
You were wrong again.
Whatever. 50-50. You can try and put it in the order or have the judge declare it in the nature of a support obligation, but the bankruptcy judge does not have to agree with the state court judge. So ultimately, you can try and equalize the amount through getting your client a larger share of the property division.
All right, let's give it up for Steve. Very thoughtful answer. All right, so remember, recap here. We're dealing with a Chapter 13 concern, not so much a Chapter 7 concern, because in a Chapter 7, the property settlement agreement is going to stand. Okay? So it's the Chapter 13 that we're concerned about, and it's actually the people who have the low income in a Chapter 13 that can really make it a huge issue, because they can get a Chapter 13 repayment plan where they're not having to pay much. And they file the bankruptcy bond. So what can we do? Did I leave that key thingy over there? Yeah, can you press a button? The forward one, Steve, come on. All right, so we want to include a hold harmless. We want to classify as a domestic support obligation, and remember, the waiver of the discharge or the determination by a state court that debts are non-dischargeable is not absolutely binding on a bankruptcy court. If you can, here's an idea, try to hold open alimony for debt indemnification, but emphasize that the payment of debt was necessary support to the party in order for him or her to pay basic necessities. So don't just say, it's a domestic support obligation, because then you have two parties who make about the same amount of money. You go, or even the other person makes more money. The person goes into Chapter 13, the court says, this is not in the nature of maintenance, so try to bolster it. I know a lot of us have standard, this is what a domestic support obligation is, but beef up your language. And I gave you an example in the packet under Example B. All right, Steve? Only one time, though, no cheating. Okay, one more. One more. All right. Your client has agreed to an unequal property division for an alimony waiver that will be paid in a lump sum 1 year after the date of divorce. All right? You represent Party A. I want you to work with your team to first make a list and identify what risks you see, and then think about the language regarding the division of debt. Again, risks we see, and then the debts. Now, Steve, that doesn't mean you get to take a time out. I might call on you again. You never know. All right, work as a group. Okay, so you spent hours in mediation working out this carefully crafted agreement that you thought was incredibly thoughtful, took into consideration the parties' financial situation, and you have this alimony buyout that's going to be paid in a lump sum 1 year after the date of divorce. So what concerns do we see? And your name again is?
Tom.
All right, we have Tom. Tom's going to help us out here. What risks do you see?
Well, you're concerned that they file a Chapter 13
Okay. And what are they trying to do?
to try to get around having to pay this lump sum.
So what can you do about it?
Well, you characterize it as a domestic support obligation.
All right. Is there anything else we can do?
You could list it as a lien against property.
How many of you think that Tom looked at my material? No, great job, Tom. Thank you, Tom. We got your buddy to look at the material. All right, so you want to make clear that in your agreement that the waiver was contingent on this payment, and that payment is necessary for the basic necessities. You want to make sure that your language is incredibly clear that this is a domestic support obligation, not a property settlement equalization payment. And you want to, if you can, try to include it as a mortgage on the property if available so that you can be a secured creditor. And example C is an option, gives you some sample language there. All right, next one. Your client just got a notice of bankruptcy filing from his or her ex. He or she brings the notice to your office, and the client also got their hands on the pleadings and brings that stack to your office as well. You represent party A, and I want you to work with a team to make a list and identify what risks you see. And then, obviously, we're not dealing with language. Write down what you're going to advise the client to do, and assume that your client indicates that they do not want to go meet with a bankruptcy attorney, despite your advice. Go see a bankruptcy, because that'd be the easy answer, right? Go take the paperwork and go down the street and talk to my bankruptcy attorney. But they don't want to see a bankruptcy attorney. So how are you going to CYA yourself in this, okay? So just take a couple minutes, and then we're going to call in somebody. Middle, you can probably guess it's going to be somebody in the middle. All right, that was a quick one. All right, Scott just told me what he would do. I mean, everybody, their first answer is, go see your bankruptcy attorney. I can't help you. Go see your bankruptcy attorney. And then you write a letter to them that says, go see your bankruptcy attorney. But what is Scott going to do? Because he knows this client is just not going to go see the bankruptcy attorney.
I would advise the person to show up to the meeting of the creditors and at the very least, tell the trustee about the situation, make sure they've seen a copy of the marital settlement agreement. It's his duty to act on behalf of the creditors, I believe, so.
All right, so step one, advise the client to contact a bankruptcy attorney. Other things that you could do, you could check the pleadings. Figure out, okay, is this a Chapter 7 or is this a Chapter 13? Because you need to make sure that I would advise my client, okay, if this is a Chapter 13, you have deadlines here. You have a proof of claim deadline that you have to file in a Chapter 13. Go see a bankruptcy attorney immediately. Because telling them to just go see a bankruptcy attorney might not be good enough. You have to say, you have a very short period of time to go see the bankruptcy attorney. They can't just wait 6 months. How many of you have had a case where a person says, oh, my ex filed bankruptcy, I didn't do anything about it, I didn't think I had to do anything about it, and it's 2 years later. So making sure that they understand that this is an imminent issue that they need to deal with. And advising them to making sure at a minimum that they attend the meeting of creditor, but in the beginning of your letter, the middle of your letter, and the end of your letter, always end it with, you need to go see your bankruptcy attorney. All right, we have 7 more minutes. All right, you have a court trial. Yeah, we have 7 more minutes, right? Scott, right? 7 more minutes? Yeah, quit cheating. All right, so we have the court trial, where you lost all of your drafting control. The judge orders party B to pay $10,000 to pay A's attorney's fees. We lost all the control and we let the judge make the decision. You represent party A. I want you to work with your team to make a list and identify what risks you see and identify what you will do and what proposed findings of fact and judgment you're going to send to the court. All right, what are you going to ask the court to do? Let's hear the chatting. Let's hear the chatting. All right, everybody, we have Dupe. And Dupe actually had a very similar situation. We heard her talking before in the collections one. Yeah, so the situation is opposing party is ordered to pay your attorney's fees, $10,000 towards your attorney's fees. So what can we do to try to make it so that, because you're making your client pay you directly, right? Yeah, so you're not going to wait to collect from the other person. But how do we make sure your client gets reimbursement from that other person?
Ask the language we put in there stating that the attorney's fees are in the nature of spousal support. Ask that language be put in there stating that the attorney's fees are in the nature of spousal support.
All right, Dupe. So we ask the court, first we want to make sure that the payments are made directly to party A, rather than having the payments made directly to you. And then ask the court to make additional findings that this is in the nature of support for party A. Attorney's fees incurred in enforcing a divorce-related obligation generally follow the characterization of that obligation. In other words, if the underlying obligation was intended to serve as support, so you incurred $10,000 in attorney's fees in order to pursue support, then the attorney's fees incurred in enforcing that obligation can be considered support. In contrast, if you're classifying the attorney's fees as enforcing a property settlement, that could be discharged under a Chapter 13. So I gave you some examples of some findings that you might want the court to use. Finally, last 3 minutes. The parties agree that all assets are going to go to Party A. All debts are refinanced and go to Party B. All assets go to Party A, and all debts are refinanced into Party B's name, and Party B files for bankruptcy. You represent Party A. You want to work with your team to make a list and identify what risks you see, and then draft language regarding the asset and debt division. You're at the final stretch. You have 2 minutes and go. All right, everybody, our in-conference David Cordell, is that how you pronounce your last name? Cordell. He's a bankruptcy attorney. And he read this, and what was the first thing that you said?
I said there might be trouble here because there's potential fraud, and the bankruptcy court really looks closely at cases where you try to do such a thing. Try to do things up and then have one of them just wash everything away.
And would that be Section 548, would it?
Yeah, that sounds good.
Okay. All right. So it defines, that section defines fraudulent to mean not only transfers intended to delay or defraud creditors, but one made for inadequate consideration by an insolvent debtor. Is that right?
Yeah, in other words, if they did anything like this, they'd have to show that there was a balance, that it wasn't really just pushing everything from one side of the scale to the other.
It sounded crafty though, right? It sounded brilliant. Oh, okay. All right, so if somebody comes to the trustee with something that looks like this, what can the trustee do?
Well, they generally have, federally they have 2 years, and in Missouri they can look back at 4 years to try to make sure that you haven't done something like, try to balance it out where there's no real balance between the parties.
All right, so thank you so much. Thank you, David. All right, yeah, the law authorizes the trustee to set aside the transfers, which takes your divorce judgment and makes a huge mess. And there's that 2-year look-back period, 4 years under Missouri. So if you're going to do something like this, you better have a very good reason for why it is fair and equitable. I can't think of many scenarios where it is fair and equitable.
If the debts are going to be refinanced, that means the creditor has to agree.
He says if the debt is going to be refinanced, that means that the creditor needs to agree.
So there's no fraud on the creditors.
So no fraud on the creditors. And it's possible. It's possible, but if you put all of the debts, and say some of the debts weren't even in the other person's name, bottom line, there's some red flags that go up for you, right?
Not if the creditor agrees.
Okay, so if you guys want to do that, make sure you get this guy to read that marital settlement agreement. He's going to get it approved for you. All right, but it is going to cause some red flags, so make sure when you have a situation where there may be a fraudulent transfer, you have a bankruptcy attorney look it over, make sure, okay, does this pass is this going to get past a fraudulent transfer issue? All right, well, thank you, everybody, and now I will turn it over to my friend Scott Trout.